Please be seated. Good afternoon, everyone. This panel just has one case this afternoon, so let's go ahead and get right to it. This case is from Shawnee County. It's number 125-410, the state of Kansas versus Jeremy A. Klein. We have for the appellant, Ms. Litpin and Mr. Nelson. Help yourself, counsel. You're both very experienced with our court, so you don't need any lecture from me. As you know, we know the facts of your case. You're not going to need to dwell on that. This hearing isn't being live streamed, so the three of us are your only audience. Oh, it is being live streamed. I did not even know that. Do you wish to reserve any time for rebuttal?
Request 2 minutes for rebuttal, please.
That is granted.
Thank you. May it please the court. This comes before this court today on a state's appeal of a motion to suppress that was granted in the district court. And a brief procedural scenario on how we got here. The defendant was charged with felony murder based on the inherently dangerous felony of fleeing and eluding, possession of methamphetamine, and some other crimes. But I believe at preliminary hearing, he was bound over on those 3 crimes. This comes from a scenario where a trooper was on patrol in uniform in a marked Kansas Highway Patrol vehicle. He saw a white sedan that passed him in the area of a drug house. And as the car passed him, he saw a spiderweb style crack in the windshield. And that's a traffic infraction for which he could pull the car over. He was concerned about the obstruction and the safety safety issues for the driver as well. And then he also noted that he thought that this car was on the hot sheet as far as stolen cars. So he turned to pursue this car and to initiate a traffic stop. It was apparent that the defendant was not going to stop. He continued to pursue him, and this, I think it was about 3-minute pursuit, ensued. And there were multiple times when the defendant was speeding at a range of 55 miles per hour and a 35, stop signs that he failed to stop at, failure to use a turn signal. We were on very narrow lanes in this area of North Topeka. So there were often times when he was traveling left of center and going in the opposite actual lane of traffic. The chase led them into a trailer court where the trooper noted that there were children not in the roadway, but near the road playing. There were some big speed bumps, so speeds were decreased throughout this, but he still continued to not cease to the authority of the trooper. They got out of the trailer court, continued on a few more roads, and at the, I'm not sure what the street it was, Taylor or Tyler, the defendant made a right, and it was actually in the oncoming lane of traffic. The trooper was behind him, saw another car coming in that oncoming lane of traffic, and determined that he would do a tactical vehicle intervention, which is bumping the back of the defendant's vehicle to cause a controlled spin out. That's what happened in this case. There was a female passenger. When the car spun out, it actually hit a telephone pole and the female passenger was injured. And days later, she did pass away from those injuries. And that's what the felony murder based on the fleeing and eluding was. So there was a motion to suppress filed by the defendant, arguing that this was excessive force under the 4th Amendment and that the evidence should be suppressed due to that excessive force. The state filed a response and there was a motion hearing, and ultimately the court, in an oral ruling, granted the motion to suppress. There are several points that the state would like to make today. If I can get to it in all of the time that I have. I want to talk about the 4th Amendment objective reasonableness standard here. But I've lost my notes page. And then there are several reasons why we believe the district court ruling in this case was erroneous. First, the district court erroneously conflated the trooper's pursuit of the defendant with the seizure of the defendant. The district court erred in ruling that the reasonable course in this traffic stop, windshield infraction, which the court described this pursuit as, would have been to decline pursuit, especially when there were oncoming cars. The district court erred in concluding that the trooper's pursuit was unnecessary because there was no suspicious of a dangerous or violent crime, and that the trooper had learned at about a minute into the stop that the car was not stolen. The district court erred in grafting KHP policies and procedures onto the 4th Amendment analysis, and then the exclusionary rule. So to start with that first 4th Amendment objectively reasonable standard, the 4th Amendment, of course, provides that the right to be free from excessive force in the course of an investigatory stop or seizure, and here a seizure happens when there is some application of physical force or the show of authority to which a defendant yields. Here, the seizure, I believe everybody agrees, is the moment that the trooper did the TVI, the moment that he bumped, there was physical force. So that's the seizure that we're talking about and whether that's unreasonable. And in determining the reasonableness of that seizure, This court should balance the nature and quality of the intrusion against the important governmental interests alleged to justify that intrusion. So it has to be from the perspective of a reasonable officer on the scene. And it must consider that oftentimes officers in these pursuits are required to make split-second decisions. We're not using hindsight here. We're using the reasonable perspective of the officer in circumstances that are often tense, uncertain, and rapidly evolving. And the motive and the intent of the officer are not relevant here. And what we're really looking at is the risk of harm that the trooper's actions pose to the defendant in light of the threat to the public that the trooper was trying to eliminate. So the first point that we make in our brief is that the district court's ruling conflated the trooper's pursuit of the defendant with the seizure of the defendant. And throughout the ruling of the district court, it's pretty short, it's just a couple paragraphs long, the district court often talks about the pursuit of the defendant and whether this violated KHP policy. And the motion to suppress actually set it up this way. It sets out this policy by the KHP to pursue, and how many times the trooper had pursued before, knew the policy, knew not to pursue within the city limits of Topeka. And the fact that the trooper should not have pursued in the first place doesn't establish that this is does not establish that this is a Fourth Amendment violation. The pursuit and choosing to pursue here is really not, it doesn't have anything to do with when the seizure happens. Again, the seizure occurs when
the fact that this started over a cracked windshield and that there were all sorts of KHP policies against even initiating this type of pursuit, those are at least factors that we should consider under the totality of the circumstances to assess the objective reasonableness. Would you at least agree with that?
I agree that we could look at it from, would a reasonable officer have known about these policies and procedures? Yes. But when it comes to actually the excessiveness of the force and using it at the time he was seized, that's what the state thinks that the court should have focused more on, rather than the initial decision to pull him over because of the cracked windshield, because that was the initial decision. But then, as many times these things do, it evolved. There was reckless driving, there was speeding. It was clear that he wasn't going to pull over right from that moment.
So is it your assertion then that anytime someone doesn't stop for an officer, no matter the reason the officer has tried to stop them, that would then be what we would use to justify the objective reasonableness, the failure to stop?
I would say the initial, I'm not sure if I'm understanding your question.
Okay, so if we ignore the cracked windshield and we say we're just assessing the objective reasonableness after the defendant failed to stop, then we would say sort of every pursuit becomes a felony pursuit.
Not necessarily, I don't think. I think here, if he would have used the excessive force and done the TVI seconds after, he would have determined, this is a cracked windshield, he needs to be pulled over, he's not pulling over, boom. And then had the excessive force then. I think that would be different than having the fleeing and eluding that took place here, the speeding, the failure to stop at stop signs, just the course of what happened throughout this pursuit, as he is constantly reevaluating that and the public safety and the danger that this car is now presenting.
I have a question about the public safety. Who do you include in the public safety?
I would say oncoming cars, pedestrians, officers.
Is the passenger included?
I would say yes, probably. I hadn't thought about the passenger being a public safety. I guess yes.
How about the defendant?
Well, it's his right to the Fourth Amendment to have unreasonable, his right is the unreasonable seizure or having a reasonable seizure. So I think that's his interest. And the governmental interest is more the public, meaning the oncoming cars, any traffic, the kids that were playing in the roadway.
Well, there weren't kids in the roadway.
Near the roadway.
In their yards are we talking about in their yards in the trailer park?
Yes.
That happened like a minute before the TVI.
Yes. as he was fleeing through the trailer park. And we acknowledge that it was slower speeds, but those at least, and I didn't mention, as this court knows, everything's on video, so we can watch the video here. But it looks like those are reduced speeds, but those are some huge speed bumps. And nonetheless, he was fleeing. He was weaving in and out of cars. And if there were children near the roadway, that still is certainly a public safety consideration for the trooper to make.
The question I have is, how do you apply these policies in an escalating situation where it starts out, I'm going to stop this car because of this cracked windshield. And then 5 minutes later, you're turning into a lane of traffic on a busy street. And you had these excessive speeds, narrow, all of the things that you talked about. How do you apply those pretty cut and dry policies to an escalating situation? Is there any problem with that? I mean, does it control, or are they ignored, or what? How are we to look at that?
For our purposes, I think the state's position is that that's a separate issue than the unreasonable seizure under the Fourth Amendment. Those policies are not put in place to protect constitutional rights. Those policies are put in place to deal with civil liabilities and lawsuits and things and public safety that deals not with the Fourth Amendment. So grafting it in that way, that kind of gets me into another section of our brief that the court did. Really honing in on the policies is not really our focus. It's the Fourth Amendment and whether at the time of the seizure, that was an unreasonable seizure on an objectively reasonable standard.
So I take it your argument is a violation of those KHP policies is immaterial.
Yeah, I mean,
Fourth Amendment analysis.
yes, and I think our brief did cite to some federal cases. I couldn't tell you the names of them off the top of my head, but I think there were a couple of circuit cases that we cited to that talked about, I think one was the Missouri Highway Patrol, and there were some other cases that say, hey, just because this is a violation of policy, even if it is, that doesn't matter for our Fourth Amendment analysis. So I think right from the motion to suppress and the way this was kind of set out for the court, the issue should have been on the Fourth Amendment excessive force, not the policies and procedures and whether he did violate the procedures of the KHP.
Okay, and so you're asking us to look at it just from the Fourth Amendment perspective of whether or not this was objectively reasonable.
Yes, sure.
And can you tell us then why you think this was objectively reasonable under, the case law that we have available to us, et cetera?
I would say if we look at, I want to say Scott versus Harris and Graham, because of how this escalated and how the pursuit went. The pursuit started out being for an initial stop for the window crack, but the public safety and the reckless driving that happened and all of the things that happened within that 3 minutes, I think, especially if we're looking at the moment right before he does actually perform the TVI or bump, you can see in the video that there is, and I think it's a black car. And
so even if it's the officers doing that substantially causes this to escalate so much, we're just supposed to look at just the point of contact between the cars. And if there was public safety issue at that point, that's all we look at and ignore the fact that it was the officer who caused this escalation to begin with. That's what I'm hearing.
Yes, I think so. And I think there was another case that talked about, and the district court also mentioned this, that they could have just terminated the pursuit. But that's not what the case law in the United States Supreme Court has held. It doesn't have to terminate. Whether he should or should not have terminated the pursuit at some point is also not what we're looking at. We're looking at just the unreasonableness of the seizure here.
Well, that's the section 1983 case that you're relying on. I understand that.
Mm-hmm. Yes, Your Honor.
Why don't you, we are just so pressed for time. We could spend all afternoon on this, but we can't. Why don't you jump into your very last issue, as I understand that, and that is that even if there's a Fourth Amendment violation here, we shouldn't apply the exclusionary rule.
Sure. I think in our brief, we set out that this is, the exclusionary rule is, the primary purpose is to deter unlawful police conduct. And we think that the internal agency handling of whether policy was violated or not can handle the deterrent, and that's the unlawful police conduct portion of this. That's enough of a deterrent. What's going to happen to that trooper because he violated policy, because of the TVI, all of that. So
Wait, you're saying it's just to deter that one? That's the purpose of the exclusionary rule, to deter the one person who violated it, not to deter all police from violating it?
no, I didn't mean to limit it to, I mean, I think it's to deter police misconduct in general. Yes, but I think that those handlings, and that would be something that all of law enforcement could see how that's handled, violations of policy, what happens to that, disciplinary actions that
Those are not public though, right? I mean, should an officer succumb to some sort of disciplinary action, that's not something that's disseminated to all police, like, by the way, this happened and you could get suspended for 4 days without pay.
That's true. I think that it would, I guess my point is that it's an internal thing that can be handled within the agency, and it doesn't need to be a suppression of the evidence under under our case here. And this does apply when it's not automatic, and that there's also the option to bring a civil action against a law enforcement officer, and that could be a deterrent as well for police misconduct and unreasonable use of force.
But also when settled, confidential.
When settled, yeah, yes, Your Honor. So I think that it shouldn't have been automatic in this case, and that there are other ways that can deter police misconduct that doesn't have to release or result in the suppression of the evidence here. I think our brief lays out really the points that we wanted to talk about, and I'm not sure how much time I have, so I guess I'll just wait.
You've used up 15.
15, okay. Sorry, Your Honor.
I'm still going to give you your 2 minutes of rebuttal, and I'll just give counsel more time if he needs it.
Please, with the court, I'm happy to be here. I'm Reed Nelson, representing Mr. Klein. I find myself in the very rare position of agreeing with law enforcement in this case. That's not my usual position, but I agree with all of the 9 members who were in the executive command above Trooper Dobler, that this was unreasonable, and in fact, the superintendent called Trooper Dobler's actions grossly negligent and willful endangerment of the lives of others, which is far beyond merely being unreasonable. And I want to rewind just a little bit about what I understand.
So that makes it automatically inadmissible in evidence. Is that right?
Absolutely.
Because a civilian board found it that way, so that makes it inadmissible as evidence.
The court found it that way.
That's right, but based upon that only.
Oh, no, not based
Did the
upon
court
that
make
only.
its own determination. or
Absolutely,
just
she did.
Said, no, we're just going to
Oh,
aim at
no.
what this board says.
Oh, no, there's much more. There is much more. In fact, what I was going to hit was the standard of review that we're operating under. And I want it very clear that Judge Pickering listened to a long hearing here. 6 witnesses, documentary evidence, video evidence. It took 2 weeks to think about it, issued an opinion. A lot of what the state is doing is wanting you to weigh the evidence about what was dangerous here and what was not. She already did that. And she made a determination after having weighed this evidence that this was a deadly stop. And under very well-established Fourth Amendment case law, it required an actual and imminent danger to the public. That's the standard that she operated under.
But it's our job to determine the legal analysis of that, right?
Correct.
I mean,
Yes, absolutely, Your Honor. Under the facts and inferences favorable to her ruling and disregarding contrary facts. So all 9 officers in the chain of command had an opinion about this, but that's not the only thing. We can move right to the incident on Tyler Street that opposing counsel talked about. Let's go right to that. So they turn the corner on Tyler Street, and we're trying to determine here whether Mr. Klein was an imminent and actual threat. And that is the factual question that Judge Pickering determined.
Now, is it your contention that we're only supposed to look to whether he was an imminent threat at that point on Tyler Street, or do we get to look at the, 2 minutes and almost 3 minutes?
We look at everything to try to judge what his reasons were when he did that. But he only offered 2 reasons. He said that everything was only a potential danger. He wanted to minimize kind of what was going on. He only talked about the kids at the trailer court and the car that was approaching on Tyler Street as the reasons for why he did this deadly, dangerous maneuver. So he turns the corner on Tyler Street. He boxes Mr. Klein's car into the dangerous lane as the black.
The standard is objective reasonableness.
Exactly.
So does it really matter what was going on in the officer's mind?
No, it doesn't. Those are only the reasons he gave. And the objective facts were the photographs that the defense presented to Judge Pickering. And those photographs showed that when they turned the corner and before the TVI was performed, that black car was parked off the side of the road and then turned its lights on, contrary to what Dobler was trying to indicate. And let's just flip that around for a second. What if Dobler was correct about this? We don't have to pay attention to what he thought. Quite frankly, he lied to Judge Pickering, and I'm going to get to that. But he claims that the car was on its way towards them. And yet he's boxing Mr. Klein's car into that dangerous lane as a car is approaching. And not only that, performs a TVI as a car is approaching at 50 miles an hour. It's all dangerous. And so, no, we do not believe what he says about the car approaching. He wouldn't have done the TVI in front of the car if it were approaching. So, and then the other reason he gave about the children at the trailer court, again, looking at the evidence most favorable to Judge Pickering's decision, just look at the videotape. There's no children. You look at this, you can see up into the yards as they're going through. There's no children. That came from Dobler. And quite honestly, Dobler lied on the stand because he took the stand and he told the judge, no one has ever told me that I cannot perform, that I cannot chase cars without a violent felony. He said that, page 42. And his
Well, the law doesn't require a violent felony in order to pursue. So,
but okay, just she could disregard his testimony is my only point. Okay.
what about the state's contention that Scott, do you think Scott stands for the proposition that basically anytime someone evades a police officer, they're engaging in imminent danger to the public?
Absolutely not. No, the officers cannot take deadly action just because somebody is fleeing from them. And this was a low-level flee. This was like a level 9. They cannot take that deadly action. They can't shoot them. They can't intentionally drive them into a pole like Dobler did. He said he knew where it was going with 100% certainty. He drove it into that pole.
So why should we employ the exclusionary rule?
Because for time out of mind, this court has followed the United States Supreme Court and applies the exclusionary rule in Fourth Amendment violations.
There's excessive force cases out there, and some in your briefs and some aren't, that say you don't always apply the exclusionary rule in these cases. In fact, courts have gone with you've got a section 1983 civil action, file it. So what's your response to that?
Well, I guess I have two responses. Number one, the prosecution, if you read the brief, their initial brief to Judge Pickering, they're the ones who cite Wong Sun on page 4 or 5 extensively, and the Kansas statute, both of which very clearly set out that suppression of the evidence is an appropriate remedy for a Fourth Amendment violation. So they told Judge Pickering to do that. They only raised two very specific exceptions, neither of which are this. And they never bring it up again. And even get the parameters of Judge Pickering's exclusion and don't say anything. So it's not preserved for review. They haven't shown where she ruled on it. But in any event, that's one thing. But to get to your question about 1983 actions, well, I think that their point is that, is there a deterrent? Is there a need for deterrence? Well, yes, there is. Trooper Dobler just goes to another job. He was at the Jackson County Sheriff's when this took place. Doesn't deter him at all. He's going to keep doing it. He enjoys it. He wants to catch the criminals. So where's the deterrent?
Is that in our record, by the way, that he's employed by a different?
Yes, it is, Your Honor. It's the first page, I think, of his testimony, maybe the second page.
Okay.
So he just goes from job to job and people employ him. So there is no deterrence that I can see. And 1983, there's qualified immunity. No, I think that not only the Kansas statute, but also Wong Song, and I'm going to quote what the prosecution gave to Judge Pickering.
Is it your contention that we owe her exclusionary decision deference? Her decision to exclude all of it?
Tell me to slow down, Steve.
Absolutely, because not only owe it deference, but it's an invited error. They asked for it. They quoted Wong Sung and said direct or indirect products of a Fourth Amendment violation are excluded. So she did that. And they also quoted the Kansas statutes that said that the courts are authorized to exclude evidence, the result of constitutional violations. So they said that right up front, and they followed it up with only two exceptions, neither of which we are talking about. So they invite the error, and the case that I think you referred to, I looked it up in their briefing on appeal, even, it's not properly raised. They cite a case which has to do with the inevitable discovery. So they've cited no authority. That's inevitable discovery, and we can talk about that, but I don't think it applies. I just don't see how this issue is preserved whatsoever for appeal. And how it's not invited there on top of that. There was absolutely, and I don't know how much time I have left.
We've still got about 4 minutes.
Okay, I would say that on the risk benefit side and the objective people who testified, and that they were coming from this at a point of objectivity. They had reviewed this as part of their jobs, and they came in and they did the risk balance. They saw no reason for Trooper Dobler's actions at all. They characterized this thing as chasing a windshield violation. That was Captain Witham who said that, chasing a windshield violation.
But it becomes more than that. I mean, when you're driving at high speeds in a dangerous area, Scott became more than what it was being pulled over for. So if we're going with the state's assertion that it is the objective analysis at the time of contact, and we're weighing the risk to the public versus the risk to the defendant, who was in the public at that time that the officer was protecting?
No one, Your Honor. No one. There was no one along that entire street, and we have to look at this in most favorable to Judge Pickering's decision. Facts, if they're conflicting,
I'm not talking about the facts. I'm talking about the legal analysis of.
Okay, well, I'll return. There was.
I don't understand how you could say that, because you've got Klein and the passenger, and you got the trooper. All of those three were involved, and the oncoming car. I mean, there are human beings all over in that were in jeopardy, weren't they not?
Well, because of Dobler's pursuit, absolutely. But no, I'm going to back off a little bit on that. not the oncoming car. I don't agree with it that it was oncoming. There were two photographs that showed that it was parked. And we look at these facts most favorable to Judge Pickering's decision, and that was it. So absolutely, this turned into a deadly dangerous thing when he TVI'd the car right into the hole, saying he knew with 100% certainty where it was going to go, familiar with the area. And we have testimony that that was a terrible place to do it by, it was Captain Witham.
So the chase, though, at the time, the pursuit. Let's assume a pursuit generally involves danger to people around. We have the defendant on one side, and then we have the officers pursuing. Who else is on the other side?
No one.
What about the passenger?
Oh, they absolutely, yes.
Which side does the passenger go on?
In terms of what?
In terms of our analysis of the objective, I mean, the standard is we're weighing the risk to the defendant versus the risk to the public.
Right.
Where does the passenger go?
Passenger is part of the public. But the standard for conducting a deadly stop is way up here. That Harris case, 80 miles an hour weaving around cars. And Trooper Dobler, following this, it was his action, okay, his deadly action that caused the death of that passenger at that time. So it wasn't, and he's the one who boxed that car into the dangerous lane.
So my question is, should he have considered the consequences of the TVI on the passenger?
Oh, absolutely, yes. I mean, if all of, yes, absolutely. If all of these objective witnesses who testified thought that the chase in broad daylight was completely unjustified, then certainly the TVI, taking that person into a pole, was totally unjustified, even more than that. And yes, he has to consider an innocent passenger when he does this. But honestly, this officer had the license plate. He had a description of the driver. There were 30 officers in the area. This was a completely unjustified maneuver on his part, and he was always set on doing this. It wasn't just at Tyler Street. He started, even before the trailer court, he was practicing a TVI. He was going to do it. And he
Well,
thought he
it's
was
dangerous
justified.
to have a car chase through a trailer park. I mean,
Right.
you would want to stop someone from driving recklessly through a trailer park. That's the reason.
That's right. And then the next question is, does it justify deadly force? Is the next question. And there's not one witness that says that besides Dobler.
Got about a half minute to wrap up.
Okay. In summary, as testified to by all the witnesses except Dobler, this was a completely unjustified maneuver from start to finish. No justification whatsoever characterized as a windshield violation. The arguments about whether suppression is the correct remedy, as I said, prosecution certainly asked the court to apply Wong Sun and apply the Kansas statute suppressing the evidence if there was a Fourth Amendment violation, except for the two very specific exceptions that they put out. It's invited error, it's not preserved, and it's the normal remedy for these violations. And it is certainly qualifies, they said, whether it's patently unconstitutional, they're going along with that. Obviously, this was. And whether this was flagrant police misconduct, which they put in their brief, would be another reason. Oh, it certainly was. So that's all well above what's required, but it was all of those things. Thank you.
May it please the court, the state just has a couple of additional comments. The state would first disagree that the oncoming car was parked and had its lights on. And it is true that the public defender, the investigator for the public defender did put on some evidence of some photographs. But the state would urge this court to use the video as its standard there to see what was going on in actual time. Not use hindsight, not use a photograph where you picked one moment out of all of those seconds of, as this pursuit was evolving, where you just picked one moment and made a still photograph of it. We would disagree that it was parked and it had its lights on. There's also a slight hill that I think that the car is coming over, so it's not clear to see until you're pretty close to being over that hill, whether the car is oncoming or parked or not. So it's a split-second decision that the trooper had to make here. The car was coming, and it also, that disagrees with what the district court found. The district court found in part of her ruling that there were oncoming cars, and that was a decision, or that had to do with why she thought the initial pursuit shouldn't have been done, especially in the fact that there was oncoming cars. So I think that disagrees with what the district court found, and she found that there were oncoming cars. And looking at the video, I just don't think that's an accurate representation that black car was parked and had its lights on. So again, we would urge this court to look at from the perspective of a reasonable officer in that time, not hindsight of an investigator who got to watch this video dozens and dozens of times like we all have. My next response would be to the defendant's claim that the trooper lied on the stand. The state would just court that the district court didn't make any credibility determinations about that testimony, didn't say that Trooper Dobler was inaccurate or lied about anything, or really weighed his credibility at all, or anyone's during her ruling. It was more of a legal analysis on whether this was a Fourth Amendment violation. And then the state disagrees that we invited any error on using the exclusionary rule. The way that I read the prosecutor's response in the district court was just stating out the law on the exclusionary rule and asking this court not to suppress because there was no Fourth Amendment violation.
Well, in district court, you argued inevitable discovery and the attenuation doctrine because he gave his statement after Miranda.
Right.
Did the state argue anything other than that in terms of its argument that we shouldn't be even applying the exclusionary rule?
Those are the only two circumstances that I can remember from the state's response was yes, because he did give an interview under Miranda and inevitable discovery. But I would just note that it's not an automatic. The exclusionary rule isn't automatic. So it's not something
I'm not focused on invited error, but I am focused a little bit on preservation of your last issue. And I guess I can go back and look at the briefs in district court and settle that for myself.
Yeah, I guess the way that I read it was preserved because we asked the court not to invoke the exclusionary rule.
It'd do that.
So, that would be my preservation argument, I suppose, as to why we can raise that now. And I think that was all of the comments that I had, and we would just ask this court to reverse the district court's ruling and find that this was not excessive force under the Fourth Amendment.
All right, counsel, thank you very much for your briefs and your arguments. This is a very difficult case. We recognize that. We'll take a close look at it and get a written decision out to you and your clients just as soon as we can. And with that, this hearing is adjourned. We will take a brief recess before the next hearing.
All rise.
You may be seated. My name is Catherine Gardner. I'll be the presiding judge for the next two cases on our docket this afternoon, and you've already met Judge Malone on my right and Judge Hill on my left. Our next case is a 20-minute case in the matter of marriage of KU appellee versus CU appellant number 124967. So may I have your appearances, please? We have CU.
Yes, but actually the option was changed from it because W is the child and
Yes.
CMU is the father, so it's in the, it'll be CMU.
CMU, thank you very much.
You're welcome.
Mark Edwards appearing on behalf of Caitlin and Katie.
Thank you. Appellant, you may begin. It's a 20-minute argument. Do you care for any?
I wish
rebuttal?
to have 3 minutes for rebuttal, please, Your Honor.
3 minutes, very good.
Yes.
You may do that.
Thank you. This is a difficult case. Judge Malone just said about the previous case that it was a difficult case. This case is difficult because of the patchwork of cases that interpret the Kansas Parentage Act. And that includes a case that was decided on August 14th of 2022 by a panel, including 2 judges in this panel. That is docket number 123883. And that case has now been granted review. That was granted on January 19th, 2023.
Which had totally different facts in this case as far
Has-
as the father's,
It
correct?
has totally different facts, Your Honor, but I think the reason that I brought it up is because it still is a question about interpreting the Kansas Parentage Act. And so pursuant to Supreme Court 6.09, I'll be filing additional authority after the oral argument today.
Thank you.
You're welcome. So yes, very different facts. I would agree with that. So there are 3 arguments here. I think one is perhaps stronger than some of the others, but first of all, that the trial court erred in finding that it was not in the CWU's best interests to connect I can't, my mouth is dry, to conduct the genetic testing pursuant to in re marriage of Ross. The second argument is the trial court erred in refusing to hear testimony on appellant's KSA 6260B motion. And in finding in those brief 5 minutes that the appellee did not commit fraud upon the court. And then one that one could argue is not properly before this court, but I have some arguments for that, is that the Kansas Supreme Court's interpretation of the Kansas Parentage Act violates appellant's equal protection rights.
As to the first 2, do you agree our standard of review for this court is an abuse of discretion standard?
I don't agree. I agree as to the first argument, Judge Gardner. I don't agree as to KSA 6260B because I think it requires an interpretation of the statute, which would be a de novo standard of review.
Okay, you can address that when you get there.
Okay, thank you, Your Honor. Regarding whether the trial court erred in finding that it was not in CWU's best interest for the genetic testing to be done, which is an abuse of discretion standard of review.
Counsel, may I interrupt you here for just
You
a
may
second? Because
absolutely, Judge Hill.
What I find unique about this particular case, and I think it's going to happen with more frequency in the future, is the cat's out of the bag here. Ross was decided before a lot of these over-the-counter tests could be accomplished. And I understand, and the Supreme Court's made it clear in that and following cases and our court and following the reasons behind Ross, the court has to determine the best interests of the child. But what do we do in a case such as this, where we now know, if assuming that it's an accurate test, and we have no evidence one way or another in this record, but assuming it's what do we do in this situation? Because the parties are going to act one way, and so I'd like for you to comment upon that, because I'm having to put this together on evaluating what the district court did.
So I think it's a very good question, Judge Hill, and it's actually something that I raised at the district court level. And as did the guardian ad litem, because that's where you got the cat is out of the bag statement. And that is that certainly I think the courts want to preserve the best interest of the child. We always, right? The courts do, lawyers do. But the issue is that we are past Ross now in technology. So what do we do with the fact that we're past Ross in the technology? And it's not a over-the-counter test either in this particular case. It was a test done by Gene Technologies, which is the same laboratory that does tests ordered by the court. So then don't we, Judge Hill, have to focus more on the facts as they present themselves to the court, as they did in this case, because
Don't ask me a
everyone knew.
question. You don't ask me a question.
No,
Tell
I say,
me
I
what
think
your-
that's what we
your
have to
best
do is
argument
we have to then focus on the facts in a more significant way, because the cat is out of the bag. Everyone in the family, in this case, knows that my client is not the father of this child. And the other difficulty is the general public is not educated to know that they can't take that test, right? That they can't go get that test without an order of the court. So I think that Ross has to be reassessed to that extent, right? We have to reassess it to that extent because, and also in INRAE RR, that in that case also the genetic testing was done absent a ruling in the matter of the marriage of Ross. So to answer your question, Judge Hill, I think that in the matter of the marriage of Ross needs to be looked at and determined what does that mean now that the technology is available? And the answer from my client's perspective is if you know what you know, you proceed from that point. You don't go backwards once it is already known. On the other hand, Judge Boehm believed that by doing that, we were eviscerating INRAE Ross. So my answer to your question would be, Judge, that we need to look at Ross again. Because I think Ross is at some level now, I'm trying to think of a good word that I want. It's a bit antiquated.
Are you asking us as an intermediate appellate court to change the law?
I'm not asking you as an intermediate appellate court to change the law because I'm aware that you're not allowed to do that. I'm
How
simply
are you
answering.
not? How are you not doing that?
I'm simply answering Judge Hill's question.
It sounds to me like you might be inviting us to reweigh the facts to determine what we think is in the child's best interests. When in fact, the district court did step through all the correct factors, I believe, and made a reasoned ruling. Disagreed with the guardian ad litem, is that correct?
Disagreed wholeheartedly. I would say disagreed with the guardian ad litem. I would say didn't even consider the guardian ad litem's opinion. And the guardian ad litem was going to write a brief in this matter and didn't, and I wish that she had. So do I believe that the district court considered all of the factors? Not all of them are in her opinion. Do I think that she considered some that weighed more heavily on behalf of the mother than the father? I do. And so I'm not asking you to reconsider or reweigh the facts either, because I know the standard of review, right? But I think that Judge Hill's question is a good one. And so then if you can't rewrite the law and the law is not yet rewritten, but the technology is out there and people are taking the tests, not only in this case, but in other cases, including INRAE RR, don't you have to look at the facts perhaps a bit differently and say, okay, the cat is out of the bag. And so now what do we do from here? That's what I started this out with, Judge Hill. It's a very difficult case. It's a difficult case altogether because as I sat down to both write this brief and then review all of the case law to come here today, the question really for me is, how does the Kansas Parentage Act define a parent? How are we defining it now? Is it defined as paternity and maternity pursuant to the Kansas Parentage Act, or is it defined as intent?
Well, the question here is clearly, is he the father or is he not? And should we make the inquiry under Ross?
Right.
And that's the only issue that we have before.
Okay, so I'm looking at
Some
that.
of
And
these other issues are policy issues that perhaps belong on the third floor of this building and not on
well,
this floor.
perhaps they do. I actually made that comment myself. So as to the factors that Judge Boehm did consider, Your Honor, I think that the court, Judge Boehm, didn't consider the relationship that CWU had with my client. And so, for example, that he had barely seen him from the time that he was 22 months old. By the time this case came before the court, he was 4 years old. He's now 6 years old. And so looking, and I think the guardian ad litem said this as well, looking at the past rather than the child's future and the inevitability of the child learning that my client is not his father. So there,
Were some of those factors you say the court didn't consider because the court thought that the biological father was not in the picture, or the mother didn't know who it was, or there was
right, and then that goes to the 6260B3 motion, right? That is based on presentations made by the mother.
Well, there's some other circumstances as well, as I understand it. He was on duty in Poland during the time of COVID, travel restrictions, he couldn't. So there wasn't any contact between him and the boy.
That
because
was
of
actually a shorter period of time, Your Honor, as there is an exhibit. That's a shorter period of time. That's not the only reason at all that he wasn't having contact with his children, because actually the younger child was born during that time period, but he had duties here in the United States as well that caused him to be away and schooling. So, the issue was raised by the guardian ad litem as to these factors, Judge Gardner, as to, you know, and I guess this is going to maybe go upstairs or maybe to the third argument, whether the child has the right to know who his father is as well, right? Does that child have a right to know that? Is that to be considered? It's not considered in the factors at the moment.
Is that a question we can answer in this case? Because the only question that's before us is what can be appealed. And that is, did the court abuse its discretion in ordering the Ross in
If the
confinement?
court's willing to listen to the third argument, and there are two reasons I can talk about why we do that, then perhaps you can. As to the abuse of discretion question, perhaps not.
Well, I think you're right when you said that you failed to preserve this argument, the third, by not raising it to the district court. It doesn't seem like your brief argued any particular exceptions.
I think I did argue an exception. One is that pursuant to Supreme Court Rule 6.02 subsection 5, I did give a reason, right? And that is, and then let me get to another place on my arguments here. So you're saying that I didn't argue?
I don't recall reading that in your brief that you preserved one of the three typical exceptions to the lack of preservation.
Under State versus Godfrey most recently. I would agree with the court about that.
Okay. In that event, I would prefer that you focus your argument on the 6260B with the remaining time you have left, because
Okay.
even with 20 minutes, time is very short, and I want to make sure you cover that. And then if you have extra time, go into the third argument, please.
Right. And the only thing, I'll just say this one thing about the third argument, Your Honor. They weren't preserved either in the same-sex marriage cases, and the court heard them. The cases that are cited in my brief. And so I think there's even more inequity to my client if they're not heard for. So I very brief, then I promise you I'll get to the 6260B3. Sometimes as a lawyer working, because I worked here, it's nice to see you again, Judge Malone, you have a lot more time to sit in a very, sort of quiet environment and look at the law, as opposed to when you get ready to write your brief and you look and go, wait a minute, here are these cases. That's a really good argument, right? So I think that this court can, I didn't raise the issue, but I think this court still can use one of those exceptions. And the exception would be that it's necessary to support justice. And the Kansas Parentage Act is just all over the place. It's everywhere. But now I'm going to go to that at your request, Judge Gardner, and I appreciate it. And that is the KSA 6260B motion argument. So the KSA 62B3 argument came about, as the court is aware from the facts of the case, when some Facebook posts came to my client, right? Facebook messages back and forth between the mother and the biological father, whom she said in, kind of interesting ways that she was absolutely certain he was the father. And the timing of that was after that test, right? The gene tech test came out. And so it was at that time, the 6260B3 motion was drafted and filed. It was filed in a timely manner. It was filed in less than a year. And it was filed based on information that my client absolutely could not have had. Did he suspect it? Absolutely. But he didn't have any hard evidence that he could present to the court, right?
So it was newly discovered.
It was newly discovered evidence, absolutely. And then pursuant to Supreme Court Rule 133, I like all those rules, I did request a hearing on behalf of my client, and Judge Boehm granted that request. And then the mother had COVID and requested a continuance. Judge Boehm granted that as well and reset the hearing, only for us to show up after my client flew in from Texas, after the mother drove in from Georgia, and for Judge Boehm to say, I'm deciding like I decided before and I'm finished.
So focus on materiality of this evidence, please.
The evidence is absolutely material to the issue in the case, and that is, was a Ross hearing appropriate? So one of the biggest things that I think concerned Judge Boehm and her ruling on the Ross issue was that the children would be left without a father. right? That they would have no father. And that, by the way, the father that there might be wasn't interested. This materially goes to that issue because the biological father does have an interest. He did say he had an interest, and it's material also in terms of her relying on the mother's testimony.
What relief are you requesting?
I'm requesting that this be remanded, reversed, remanded, and that it be reassigned on remand.
And directions to inquire what?
Directions to actually hear the evidence, directions to allow my client the one avenue for relief, which he had, which is talked about in Ray Finks. And that is to actually hear the evidence and consider where it's clear and convincing evidence that fraud was committed upon the court.
So to hold an evidentiary hearing on the 6260B3.
Yes, Your Honor. Exactly, which is what we requested. So that's what the relief that we're requesting pursuant.
And that would also require a rehearing on the Ross hearing.
It would indeed. And you know, the materiality is it could significantly then change that, right? Because if we now know that there is a father and a father pursuant to the evidence that we have for the 6260B3 said he would be willing to take a paternity test. His wife indicated they would both, you know, as a couple, family, be willing to take that paternity test. And that if the child is his, he wants to be involved in his life. That's a very different position for the court than we don't really know who the father is, but we do know that he doesn't want anything to do with the child.
The existence of the father, the existence of the child means that there's his father, does there not? Because if there was no father, there'd be no child.
That's true, Your Honor, but if the court reads Judge Boehm's opinion, that was something that mattered to her a great deal. And I have a great deal of respect for Judge Boehm. I appear in front of her often. You know, we no longer like to use the term bastardizing a child, right? Because it has some political implications that we no longer use or don't like to use. So, but I do think it was important to Judge Boehm that this child have a father. But as I wrote in my brief, does having a father simply mean someone who pays child support? And materiality, this may not be material, Your Honor, I think it is. As to the facts, if we go back again and look at this case, is that, you know, my client had history as it relates to, you know, his mother being treated differently in her family, understanding she was being treated differently, never understanding why, then finding out she was adopted. But by the time she found out she was adopted, her biological father was dead. And so in Re RR, and I promise I'm going to file that letter of additional authority, in Re RR focuses a great deal on, and I don't in my brief, admittedly, on what is the right of the child. But the guardian ad litem did, and I did, and so did my client in testimony. Does this child have a right to know who his father is? Our argument would be yes.
Back to materiality.
Yes.
Didn't the trial court also find mother's testimony to be expressly to be credible? And
You mean
does that make a difference here?
6260B3 motion?
No, in the original Ross hearing.
She did, and the guardian ad litem and myself both disagreed, and the guardian ad litem put it very bluntly that the mother's entire testimony was a lie.
And so doesn't this evidence that you tried to get in at the 60B3 relate to that as well?
Absolutely. I think it is the most significant evidence that relates to it is that, right, that the mother was not a credible witness and that she lied. But the answer to that question is yes. And I understand, Judge Gardner, and I respect that the court believes that the constitutional argument is not properly before this court. And that I didn't cite a specific exception to that. And so,
And even if you had, it's very prudential. I mean, we don't have to take it just because you recite all three exceptions. It's up
Right.
to us.
it is up to you. It is up to you. But I would ask as a practitioner, what I could express to the court is there is a great deal of confusion regarding the Kansas Parentage Act. There's a great deal of confusion about what happens with same-sex couples versus couples who are not same-sex couples, grandmothers, right? Grandmothers, two, one who was a parent in TMMR, one who was a parent in that she had orders who caused her to be a parent, had shared legal custody, had almost primary residential custody, right? So she's relying on certain cases only to find out that she can't parent her grandchild. There are many cases with I mean, what a family looks like.
A host of facts, which we are not able to determine as an appellate court. That's our reluctance because these are important issues and they're unsettled issues. but they're not issues that have been fully fleshed out by the district court or any ruling. We're a court of review. And
Well-
that's my personal preference on this type of matter. You have.
I
about
agree, I
one-
agree that you're a court of review, but I also agree with Justice Siegel that these courts have not you personally, Judge Gardner, have broken the Kansas Parentage Act by a patchwork of cases that we as practitioners then don't know what we can or can't do,
But
right?
counsel, we're limited to the facts of the case that is before us.
I appreciate that.
And we don't have a same-sex couple here.
But we
We've
do-
got men and women
But we do have a,
and the rest is just, we could write all sorts of diatribes in our opinion, but that's not the force of law. That's just venting. I mean, that's that. In order for us to give legal effect to our opinion, we must deal with the facts of the case that's before us.
well, and I
We
understand.
have to limit our ruling on the facts that are in your case, not in some case that Justice Stiegel is writing about.
You have about 1 minute.
Well, then what I would ask the court to do, because I believe it's my strongest argument, is to really look at that KSA 6260B3 motion and the summary dismissal of that motion and the facts that would have been presented, which are material, which could have then given my client the only relief that he had that would have led us back to a second Ross hearing. And I would ask the court to remand for that reason and to remand and on remand to reassign this case with all due respect to Judge Bain.
Thank you very much.
Thank you, Your Honor. Thank you, Judge Hill and Judge Malone.
Well, may it please the court. Since 1989, the Ross case has provided us with the procedural protocol about how we deal with paternity cases. And so the question in this case is that, if you look at the Ross case, there's 6 head notes. And 5 of those head notes refer to the best interest of the child. And, that phrase, the best interest of the child, in this case, our trial court conducted 2 hearings, had 8 witnesses. There was over 228 pages of transcript. There was 41 pictures introduced into evidence to show the relationship between the minor child and his father. And after the conclusion of all that, the court within 7 days issued a memorandum decision on February the 18th, 2021, that outlined all the reasons of why in this particular case, it was not in the child's best interest to have paternity testing done.
It's unusual for a district court, in my experience, having just seen them as an appellate judge, to have disagreed with the guardian ad litem's recommendation as to the best interests of the child. What was that all about here? I don't know what the guardian ad litem bottom line was.
Well, first of all, the guardian ad litem filed her pretrial brief on January the 27th. The hearing was held where the actual evidence was going to be introduced on February 1st, and then the second hearing was February the 11th. Now, how do you file a brief where you haven't even heard the evidence yet? And in this case, it was very obvious that the guardian ad litem, based upon her interviews, some of the people that she interviewed were not even mentioned because she didn't interview them, and they subsequently heard the evidence in the court. Also, I think that the judge was trying to deal with it in a very political, correct way when she just said, she mentioned in her decision, she said, well, I've reviewed the guardian ad litem's pre-trial brief. The guardian ad litem made her decision before all the evidence came in. And accordingly, it seems a little strange that in this case, that there's so much emphasis placed in the guardian ad litem's opinion, Because it's my understanding that guardian ad litems are supposed to maybe make an oral presentation of the court at the conclusion of the evidence and then go ahead and write something up if the court wants it. But to basically cast her a hand into the lot and say, well, I've already made up my mind, certainly seemed to be inappropriate. And, I don't, we're a small judicial district. We don't have a lot of guardian ad litems. And I think the judge was being very gentle with the guardian ad litem about emphasizing, hey, you filed your pre-trial brief before all the evidence and arguments came in. So that's what I think that's all about.
Appreciate that.
What we had in this case, it's a beautiful decision that the judge went through in this particular case. And
Counsel, I've asked your opposing counsel, I'll ask you the same question. I'm sitting here perplexed about what to do about the efficacy of the Ross opinion in this day and age, where it is fairly easy for these people to go out and get these tests done. And I guess they can be accurate and
well, first,
what do we deal with? I mean, the reality is, are we to say that this man is still the father, or we're going to continue to say he is the father, even though he's not the biological father? Is that where we are? Is that where we are in this situation?
well, first of all, I would think that in this case, and I think it's important for this panel to understand that biological test, if you look at it, it's very clear on it. This test is not to be used for legal purposes. There's been reference that this is the same company that does do the court-ordered paternity test. That's not in evidence. So I don't want you to walk away thinking, well, you can do this, because that's not the case. And thirdly, in that case, if you look again at the test, it was done up in Canada. Now, how is a person going to have jurisdiction over somebody in Canada, in Junction City, Kansas, to determine this kind of an issue? So that's the reason why there's a lot of, and I refer to it as a drugstore test, and that's what it is. So we have a lot of things going on in our society that deal with, things that you can get done quickly. We have lots of evidence out there allegedly anymore on Facebook and on our computers, but that's really not what I think this panel needs to get involved in. I think what we have here is a case that the drugstore test was completely without any foundation, and we have no idea whether or not it's valid. And I think that is the important decision.
So in your view, the purposes that gave rise to the Ross decision still exist. The trial court to determine what's in the best interest of the child before ordering testing.
Absolutely, Judge.
That
Absolutely.
hasn't changed even as technology has changed.
And you can see what at the great pain that Judge Boehm went through of looking at the pictures and made it very clear that this had a great relationship. And the fact of the matter is that the father was not a credible witness. He sat there on the witness stand telling me that the child was 35 months old when in fact, when the case started, when in fact he was 39 months old. He tried to tell us that he had only had 22 months, and that's another fallacy of the guardian ad litem's report. She said, well, he only really had 22 months of close contact with the child, even though we're dealing with somebody that was 3 and 4 years old. That wasn't the facts at all. In military communities, the whole introduction of Skype and the fact that in this case, the father's brother-in-law testified about how there was interaction between that child and his father in Poland. This idea that soldiers go off to Poland and have no contact with their family is just not a correct assumption and a correct view. In fact, most of the brigades and most of the companies require their soldier to have contact with their family. So in this case, the testimony was that the child got very animated and excited when his father was on the screen. So we have all of this period of absence that they try to rely on, that the father did. We have all these pictures showing during the period of time where he said he wasn't around Fort Riley, they were attending a Halloween parade and doing things. So I think it's important here. The judge made the specific finding that this father was not a credible witness. And to read her opinion, it was very, very clear. And I'm not going to recite her opinion because I think that the judge hit the nail on the head. She hit all of the boxes checked. She went down to the Elrod treatise and she showed point by point by point what is in this child's best interest. It wasn't a case of making a decision about what is in this father's best interest. This father, time and time again, rejected the idea of getting a paternity test. And yeah, now he wants to do it. Well, frankly, you know, his own mother said, told him repeatedly, get a paternity test. His sister told him that. And yet he's testified, he said, well, I had doubts about my paternity throughout the marriage. Well, if he had so many doubts and he had so much urging by his family to get a paternity test, I think he would have done so. So
address the 260B3 motion, please.
Oh, Judge, you know, there were two motions filed for post-trial relief. Neither one of them had one stitch of affidavits. There was no depositions attached. There was nothing at all for us to support either one of those requests.
Well, you would agree, wouldn't you? You don't have to attach evidence to your motion to get an evidentiary hearing. You don't have to attach something that would be admissible in evidence. They attached something, did they not, to their brief or to their motion?
They attached something that allegedly came from Anthony Weatherhill. And I want the court to take a good look at that too. This idea that they didn't discover this until well after the fact. Anthony Weatherhill was listed as a witness on their witness list prior to the February 1st Ross hearing.
To testify to what?
I don't know. And the fact of the matter is he was listed, issued a subpoena, and for some reason, he wasn't ever called. So who knows what they knew and what they didn't know. And in fact, I think that had a lot to do with the judge's decision because we were dealing with a person that was found not to be credible in his testimony about what he did know and what he didn't know.
But the particular evidence that essentially from Mr. Weatherhill was not in fact created till after the Ross hearing, was it? The Facebook message or whatever.
I'm not sure.
Okay.
I'm not
That's
sure.
fine.
And the fact of the matter is that the evidence wasn't admissible. Even, you know, you can't, you shouldn't be able to tip the scale in an effort to get a rehearing when you're relying on stuff that's not admissible. And that wasn't admissible.
But not as a piece of paper. You'd have to call a witness.
Well, I guess it was fraught with hearsay and there wasn't any kind of supporting document from
Are they
Anthony
entitled to a
Weatherhill.
hearing?
Sir?
Are they entitled to a hearing on it, is the question, isn't it?
No, the judge made it very clear. She said, I've gone and reviewed the entire record. And she was very, I thought, somewhat emotional. And she said, you are the father of this child. And I don't find that there's been any fraud committed on me based upon the record that's in front of me. And she made that specific finding based upon the record that was in front of her. So in that respect, she made the determination that she was not, and she had the discretion to do that. And the way I read the case, this is a discretionary matter with the court. And again, we know that judicial discretion is abused if judicial action is arbitrary, fanciful, or unreasonable. And if no reasonable person would have taken the view adopted by the trial court. We also, number two, be based on an error of law. If the discretion is guided by an erroneous legal conclusion, that wasn't the case. Or based on error of fact, substantial competent evidence does not support a factual finding on which a prerequisite conclusion of law or exercise of discretion is based. This child is turned 6 years old. And, I think at some point in time, the court following Ross made a finding that there was a very good relationship between this young man and his father. Many military families have a situation where they're gone a lot and the children don't have a chance to spend a lot of time with their father, but they have a father. And I think that's a very important thing. And that's what was always behind Ross. And in this case, it's very clear that they want you to view this matter in what is the father's best interest and not the child's best interest. And I'd ask you to go ahead and affirm the lower court's decision, unless there's other questions.
Thank you, counsel.
Yes.
I do have answers to a number of the questions that were asked. Judge Gardner, you asked, isn't it uncommon for the judge to disagree with the guardian ad litem? It is. And Tish Moracle has been practicing domestic law for more than 25 years. She's known to the court, she's known to the judges, and it's the opinion of the petitioner, as well as myself as his counsel, that the judge simply ignored her brief. And it is a pretrial brief. It's always a pretrial brief because the guardian ad litem is appointed in the midst of the case, does an investigation, drafts the brief and files it. It's not filed after court.
Well, that's not the way it is in every district council.
Okay,
A
well,
lot of
that's
districts, they follow it.
that's the way that it's done in Geary County. That's the way that it's done in Saline County, which is where Ms. Moracle practices law. That's the way that it's done in Riley County. That's the way that it's done in the entire 8th Judicial District and districts close to it.
We don't have any evidence of that, but thank you for your input.
There's evidence of it by way of the order appointing guardian ad litem and the rule that applies to guardian ad litem, Supreme Court Rule 110A, as to what her obligations and duties are. So it is uncommon that judges don't agree with the guardian ad litem. As for any, and it's in the brief as well, that somehow Judge Boehm was gently chiding Ms. Moracle for her behavior. There's absolutely no evidence to support that either. She did her job, she did it well, whether the court agrees with her or disagrees with her. I want to also be clear for the record that the genetic tests were not offered as evidence. So there's some argument both in the brief and by Mr. Edwards here today that would certainly seem to cause this court to believe they were. The other thing is that Mr. Wetherill was on my witness list and was deployed to Poland. So he was not available at the Ross hearing. That's the reason he wasn't there.
So I understand who he is. He's the one that had access to the Facebook
He's the,
page that allowed your client to get the information concerning the.
Mr. Wetherill was the mother's boyfriend who moved into the home that she used to share with my client on base before they were divorced. And they had a relationship. He too was 18 years old when that started.
I'm trying to figure out all of these.
Right. So yes, it was the boyfriend that she had after the parties separated. And then when Mr. Wetherill and mother broke up, he still had access to her Facebook page. Apparently, she had logged in on his phone.
All right.
And so any intimation that evidence was available to us before we had it is absolutely false. We did not have it. We didn't have any way to access it. And so that's who Mr. Wetherill is.
Thank you.
You're welcome, Your Honor. And your question about the one, Judge Hill, that you keep asking and that I have asked throughout this case, and that is, what do we do with Ross understanding the limits of this court's power? What do we do with Ross when genetic tests are available? I guess we need to speak to the legislature, because you don't have that authority. And certainly I don't have that authority, but something needs to be done, because the fact is those tests are happening. And again, in NRA RR, which will now be up for review, although not specifically on that issue. And there was a question as to why Mr. Wetherell was on the record as was going to be a witness, if the court wants to answer that question. It was to show a pattern of behavior of the mother in basically dating 18-year-old, 19-year-old men in the military, marrying them, having close relationships with them, and taking advantage of them.
Totally different issue than what.
Right, than what we ended up finding out. That's right, Shauna. And Mr. Edwards indicated that the child is now 6 years old. The child is now 6 years old and living in South Dakota with mother's new husband, who was also an 18-year-old member of the military when she married him. And again, I would ask the court to remand this matter because you asked also whether my client has a right to a hearing pursuant to KSA 6260B3, and our answer would be absolutely that he does. And that the court didn't say, I've read the record. She simply said, I'm going with what I had before. And she didn't make any finding as to fraud. I actually had to ask the question. And I do believe that she was emotional. I agree with that. But I said to her, with all due respect to the court, is the court going to make a finding as to fraud? She said there was no fraud. There was no evidence. We didn't have an opportunity to present evidence to whether for her to know that or make that determination by clear and convincing evidence. And so we're asking for that opportunity on remand and on reassignment, Your Honor. I appreciate all three of you. Thank you for your time.
Thank you to both counsel for your arguments. We appreciate them. Interesting case. We will get you written decisions when we can. Take it under advisement.
Thank you. It's nice to see you all in person.
It is nice to be here in person. Last case on the docket is case number 124800, State of Kansas appellee versus Andrew Ford Insminger appellant.
Insminger?
Is that correct? Insminger, thank you. Appearances, please. When you're ready. You?
May it please the court, Andrew Ansminger appears with counsel Caspershire and appellate defender office.
Thank you. And thank you for doing double duty today with oral arguments.
Thank you for accommodating my schedule.
Well, we appreciate your willingness to travel from Wichita and do one there and do one here.
I was wondering, isn't there a way you could have said something, I think, to our chief's office, so you wouldn't have to do a turnpike warrior?
Well, it's a fun story, Your Honor. I was originally slated to be here at 9 a.m. and there at 9 a.m. So I called over and said, I aim to please, but there's a limit to what I can do. And that's how we ended up here. So at any rate, I do appreciate the opportunity to be here today.
Would you like some rebuttal time?
I would, Your Honor. Thank you for reminding me. Could I please have 3 minutes?
You may.
This appeal is about what the state needs to do to keep Andrew subject to serving a prison sentence for the rest of his life and also subject to KORA registration for the rest of his life. Andrew pled guilty to 2 level 5 border box offenses, and the district court imposed lifetime post-release supervision by finding that he was 18 years old. It's our position that that violated Apprendi. The district court ordered lifetime offender registration by finding that the victims of these offenses were less than 14 years old. And it's our position that that was not consistent with the factual basis that Andrew pled guilty to, or to the law, or with the law. Lifetime post-release and lifetime registration are a big deal. A lifetime post-release sentence is a life sentence, and it needs to be treated like one. If you are serving lifetime post-release, there are 2 possible outcomes for you. Either you're going to die still reporting to a parole officer, or you're going to die in prison. There is no third way. Lifetime registration is similarly permanent, and this court knows the lengthy prison sentences that people serve when they can't live up to what that civil regulatory scheme demands of them. My point here is, when we look at orders like these, we need to make sure that all of the I's are dotted and all of the T's are crossed, because it is very important, particularly when they come together. And that careful review here demands that Andrew get a chance to outlive his sentence in this case.
Was the only evidence that I'll call them the victims, appeared to be under age 12 or appeared to be about 12 years old?
Yes, the factual basis said that the individuals in the videos appeared to be, I believe, under 12 and under 13 was the language that they used.
And was there any contradictory evidence?
Yes, at the close of the factual basis, it said, for the purposes of the plea, these were visual depictions of children under the age of 18.
Well, I know that one sentence is in there, but as far as the rest of the factual basis is, the children appeared to be no older than 12. Plus, your client agreed with that, right?
He agreed to that, but it boils down to the difference between appearances and what the purpose of the plea was, Your Honor. He agreed that they appeared to be under 13, under 12, but then we have an explicit statement that says, for the purposes of the plea, these were visual depictions of people under the age of 18. So it's our position that that language states exactly what the purpose of this plea was, which was to establish that they were under the age of 18. And that was the element of the offense that he pled to, not that they were under 14 or 13, but that they were under 18. So it tracks with the elements he was charged with.
They were under 18 and they appeared to be 12 or younger.
Yes.
So how does that contradict? I mean, why is that not sufficient evidence for us to find that these victims were in fact of the prohibited age, under 14?
Because again, it boils down to the difference between appearances can be deceiving, but for the purposes of this plea, everyone agrees that the children were under 18. And I think there's a second problem with the lifetime registration order, and it's a problem that some members of this panel and other panels have considered before. And that is that there's a difference between how old somebody in a picture is and how old a victim is at the time an offense is actually committed. And I think that recent amendments to the core scheme have gone a long way in terms of clarifying that this is an important difference. I say that because Andrew is serving lifetime registration because the district court found that these individuals in the photo were under 14 at the time the photo was taken. We really have no idea how old these individuals are at the time the possession offense actually takes place. Based on that, he has to register for the rest of his life. In 2022, amendments to CORA went into place that essentially made an aggravated version of the offense that Andrew committed punishable by 25 years of registration, not lifetime. In other words, if Andrew had committed the offense of internet trading rather than sexual exploitation, which is a base sexual exploitation plus making these things available to others on the internet, by statute, he would be registering for 25 years, not for the rest of his life. And so I understand the concern of the Haynes panel and the Kewish panel in saying that it's going to be very difficult to make these factual findings with respect to how old individuals in these videos are going to be at the time of the specific offense. I get that. It is going to be hard. But it's not impossible, A, and B, if the legislature had intended for people to register for the rest of their lives based on the content of the images and not based on the age of the victims at the time of the offense, then we wouldn't see the 2022 amendments written the way they are.
Well, but despite the fact they amended that, they didn't amend 2155-10A2, which is the statute here, I believe, which under which the victim's age at the time of the offense is not an element.
No, it is not. And that's part of the argument here, Your Honor, is that, you know, these images could be 10, 20, 30 years old, and this would still be a crime, right? This would still be a crime. It doesn't matter.
That makes sense.
What's that?
Why doesn't that make sense?
Well, it doesn't make sense because the statute can't mean one thing is applied to subsections A, 1, 3, and 4, and something different is applied to subsection 2. So it can't be the fact that for sections 1, 3, and 4, which essentially simplifying the scheme greatly, sections 1, 3, and 4 say promoting this kind of act is sexual exploitation. And we looked to, of course, in those cases, the age of the victim at the time the offense is committed, because there's no place else to look. There is no video, there is no image.
But an image lasts forever.
An image
So-
does last.
I mean, theoretically.
Yeah.
So why shouldn't we go with a different analysis for that subsection of the statute?
Because that requires you to say this language means one thing as opposed to subsection 2, but something different as applied to 1, 3, and 4.
But the legislature is fully capable of doing that if they believe that the possession of these images in itself are bad. These are bad images, and no matter when they were taken, if they're under, what is it, 14?
Yes.
They're under 14. Doesn't matter when it was taken, whether it was 10 years earlier or not. It's bad. Why can't it be like that?
Well, I think the problem, Your Honor, is I think that the statute is ambiguous because the statute says, and I don't have it right here in front of me, but it says something to the extent of if the court finds that the victim was 14 years or less, lifetime post-release. It doesn't say when. It doesn't say when we make that determination. And so in resolving that ambiguity, the Haynes panel and the Kewish panel said, well, this is going to be very difficult, close to impossible in some cases to do for subsection 2. If we're looking at the age of the individuals pictured at the time of the new offense. And that's true, but I still don't think you can say, well, that language means one thing as to subsections 1, 3, and 4, and something different as to subsection 2. And I really don't think you can say that in light of the 2022 amendments that make an aggravated version of what Andrew pled to, 25 years registration. I think in resolving the ambiguity, the court has to take all of that into consideration.
But you don't remember which language is ambiguous?
I can look up the statute when I get back to council table, but I
just don't remember you're arguing ambiguity in your brief, so I didn't look at any language very specifically, but yeah, that'd be helpful, thanks.
I'll look it up, Your Honor. I'll look it up because I think it's in my brief, but I'll find it regardless. I'd also like to talk a little bit about lifetime post-release supervision. And at bottom, I'll make this as simple as I can. What we're asking here is that lifetime post-release sentences get treated the same way as Jessica's Law lifetime sentences. Somebody that is 40 years old and is charged with an off-grid Jessica's Law offense can absolutely plead to an on-grid version of the offense. The only difference is their age is removed from the charging document and they don't agree to it in the factual basis. Post-release is part of a sentence. Lifetime post-release is an enhanced sentence based on a finding of age. Unless Andrew pleads to his age, a judge cannot find it. Apprendi forbids that. It forbids that kind of fact-finding in the Jessica's Law context, and it needs to be prohibited in the lifetime post-release context as well.
But this defendant did sign a plea agreement which stated his age, correct?
He did, but that is different from waiving your right to have that fact proven to a jury.
But he admitted the fact to the jury.
There was no jury, Your Honor.
Well, in lieu of a jury, he admitted the fact, thus removing it from Apprendi's rule that you must prove it to a jury.
I disagree that there was a knowing and voluntary waiver here, Your Honor.
Apprendi doesn't speak in terms of waiver. It speaks in terms of an admission by the defendant, does it not?
But you have a right to have that fact proven to a jury until you waive it.
Unless
There
you
was no-
admit it.
But he did not. But he did not waive the right to have that fact proven to a jury. He was not explained the right to have that fact proven to a jury. In fact, at one point, the district court told him that he would be subject to 24 months of post-release supervision at his plea colloquy. And that's important. There needs to be, and on this point, Judge Atchison wrote a dissenting opinion in the Schmiel case, which I encourage this panel to read. Because he takes up this waiver issue and explains it probably better than I can, to be quite honest with you all.
We'll tell him that.
Do, please do, Your Honor.
You have about 2 minutes.
I appreciate that. Details matter when we're talking about things as important as lifetime post-release supervision, and when we're talking about things as important as lifetime registration. We're asking this court to take a hard look at the statutory scheme and to do the hard work of determining whether the state put on the evidence it needed to make Andrew register for the rest of his life. We're asking this court to take a hard look at Judge Atchison's dissenting opinion in Schmiel. And we're asking this court to find that Andrew should get an opportunity to pay his debt to society and move on with his life before he dies. Thank you.
Thank you, counsel.
May it please the court, the state appears by Deputy District Attorney Jody Lippin. I'm going to start with the first issue in this case and hit on our preservation argument. And it's the state's position here is that this is actually not preserved for this court to reach the merits here.
Are you talking about the sufficiency of the argument evidence?
Yes, the first issue. I know we've raised preservation, all of them. I'm not going to hit on it on the other two issues, just this one. So there was an objection to the state's request that there be a lifetime registration under Cora here. And the parties agreed at the sentencing hearing to let the court take a look at the transcript of the plea to check what the prosecutor said during the factual basis. Both parties were okay with that. The district court did that, and they had a hearing where the court determined that the state had established that those victims appeared no older than 12, appeared no older than 14. She also used the term prepubescent for the boys and pubescent for the female. And there was, again, like this court has pointed out, no objection to that factual basis on that detail. I think there was an objection regarding whether the files were found in the recycle bin or on his actual computer, but there was no objection as to the age of the victims. So there was a later hearing where the district court had determined that the children were less than 14 years old and lifetime registration under Cora was required. And the defendant's attorney requested to see that plea hearing transcript just to confirm what it said. And he said, I trust that's what it says, if that's what it says. And the court says that it would pass along the transcript to counsel. And if he said if there was an issue that he needed to raise, he would. No other issue was raised, no other motion was raised. So the state's arguing that this isn't preserved because there was no other objection to the ages past what the defense counsel said, and hey, I need to check that transcript. So we're taking that as a concession as to the ages, and at the factual basis that the prosecutor laid out did in fact provide evidence that they appeared no older than 12 and no older than 14.
Well, it's a sufficiency of the evidence argument, isn't it? I mean, I know it's not a trial here, but it was a plea. And so the judge was looking at the transcripts. And now the issue is, was there sufficient evidence that these children were under 14, right?
I have, substantial competent evidence, to support the district court's finding.
I thought you could always challenge the sufficiency of the evidence on an appeal. You know, the preservation is not even an issue.
You can challenge it in a strict sufficiency of the evidence, but he's not challenging the sufficiency of the evidence of his convictions here. It's just the district court's finding substantial competent, whether substantial competent evidence supports her finding. So, and really it's the language, if that's what it says, then that's what it says. I mean, that to me seems to be a concession that if the district, or if the prosecutor really said they appear to be no older than 12 and no older than 14, then I trust that.
Well, no older than 14 could mean 14, right?
It could, no older than 14 could be 14 or 14 years or less, yes. But we still have two boys in the videos who were appeared no older than 12. So, and again, we would go back to the no objection was raised during the plea hearing on that specific fact. And we do recognize that this has been raised for the first time on appeal, and panels of this court have reached the merits of the issue as well. Alternatively, we would argue that substantial competent evidence supports the district court's finding that lifetime registration here under Cora is required. For the other two issues, the second issue, we would ask this court to rely on state versus or find persuasive state versus Haynes and state versus Kewish, like we put in our brief. Two other panels of this court which have rejected the same argument brought by the defendant.
But those were before Cora amendments, the legislature's amendments to the Cora statutes.
True, and our argument is to the extent that those amendments apply to other crimes, that's not really relevant to the crime that we have here or the statutes that we have here. As Judge Hill pointed out, if the legislature wants to change those, they can. That's not the crimes that we have today for the sexual exploitation of a child, which is applicable here. And for the third issue, as Your Honor, Judge Gardner was saying, we agree that there's no Apprendi violation when we have an admission of age here. And I believe our brief pointed out 3 times, I think, where once in the written plea agreement where the date of birth is listed, once in a notice of duty to register where the defendant's date of birth was listed. And in that plea agreement, of course, he signs the section that says, I read this, I understand it, and I agree with it. So he agrees that he was, that was his birthday, and I believe it was 29 years old. And also the PSI listed his age as 29, and there was no objection to that at sentencing as well. So our position is because he did admit to his age, this court should find that there's no Apprendi violation and that lifetime post-release supervision is appropriate here.
There's a difference between admitting and not objecting, right? Isn't the only admission that he was over 18 would be where he initialed the plea agreement that had his birth date right on there. He initialed it right by his birthday.
He did,
He
yes.
was born in 1991.
Yes, he initialed.
An admission.
Yes, I agree. It's not the same as not objecting to the PSI, but his age was listed on there. But yes, that is an admission where he did agree that his date of birth was, that date. And then I think at the bottom, there was another section that I was referring to as reading the entire section. And of course, he did read the sign the written plea agreement as well in total. And then the other point I would like to make is even if this was an Apprendi error, that's not a structural error. This court can find it's harmless if the court finds beyond a reasonable doubt that the sentencing factor was uncontested and it was supported by overwhelming evidence. So again, the defendant's age here was never disputed or challenged at any point during the proceedings, and he did admit to or didn't object to his age several times as well. So our alternative argument would be that this court can find this Apprendi issue or error harmless if they do find that there was an error here. And I don't believe I have any further presentation on it.
Thank you.
I'd like to touch on just a couple of things quickly. First, the court had questions about which statutes we're talking about and which language was ambiguous. I'll direct the court to pages 9 and 10 of my brief. I did not quote the statutes in there, and I don't have the statute book in front of me. But that is where I made the argument that the statutory language is ambiguous and that this court has to look to the statutory scheme as a whole to interpret what it should mean.
Thank you.
Returning to the lifetime post-release issue, we work in a system where plea agreements run the show. North of 90% of our cases are resolved by plea agreements, I think, as we all know. And your punishment is capped by what you plead to, not by what you did. You can like that, you can hate it, but that's what we live with. For that reason, or at least related to that, if I walk into court for arraignment and I say, Judge, I'm guilty, let's just do the sentencing. district court can't say, all right, well, if you're admitting you're guilty, then I guess we'll just do the sentencing. We have a plea colloquy. We make sure that the accused has been appraised of his right to have a trial, appraised of his right to have all of these facts proven to a jury, appraised of his right to have a jury unanimously find those facts. That's what didn't happen here with respect to the age finding. Now, I understand the argument that this isn't really what we were fighting about, but to some extent, in a system where we rely on plea agreements, it misses the point. The same way that somebody who is 40 and charged with a Jessica's Law offense can plead to something else, Andrew can plead to something that requires a post-release term of less than life. And that's what he did by not agreeing to his age in the factual basis. And putting his age into the plea agreement is not an adequate substitute. It doesn't come along with any of the procedural safeguards that we attach to guilty pleas and that we expect courts to use at any kind of guilty plea. And so for those reasons, we are asking this court to reverse both the lifetime post-release sentence and the lifetime registration order.
Mr. Shearer, back when I was on the district court bench, it would take me 45 minutes to take a guilty plea.
Yes.
It's not just.
And I've done district court work as well, and it gets tedious. I get it. It's monotonous. And a lot of times you're telling people things they already know, but we do it because it's important. We do it because the rights we're protecting are that important. And that's my point, Your Honor. Thank you.
Thank you to both counsel. We appreciate the good arguments. We'll take the case under advisement and get it to you when we can. Court is now in recess.